the hearing of the Committee on Justice to discuss the committee report on the impeachment of Chairman Juan Andres Bautista, and likewise of the complaint for impeachment against Supreme Court Chief Justice Maria Lourdes Sereno is now called to order.
Mr. Chair, good morning. I move for the calling of the roll.
Comsec, please call the roll.
Good morning, Your Honor. Roll call of members of the Committee on Justice. The Honorable Chairman Reynaldo Umali, the Honorable Vice Chairpersons Vicente Ching Veloso, Doy Leachon, Henry Wominal, Arinulfo Fuentebella, Strike Revilla. The regular members of the Committee on Justice, Honorable Representatives Roy Loyola, Marlene Primicias Agabas, Jerry Treñas, Lucy Gomez, Rosemary Baby Arenas, Bayani Fernando, Ruel Peter Gonzaga, Ramon Rocamora, Federico Sandoval II, Horacio Swansing Jr., Jericho Jonas Nograles, Lawrence Lemuel Fortun, Munir Arbizon, Arthur Yap, Divina Grace Yu, Noel Villanueva, Manuel Luis Lopez, Edward Vera Maceda, Jose Christopher Belmonte, Kakabag Au, Josephine Ramirez Sato, Xavier Jesus Romualdo, Juliet Marie Ferrer, Edwin Ong, Rodel Batucabe, Ron Salo, Sherwin Tugna, Carlos Roman Uybareta, Salvador Bilaro Jr., Antonio Florendo, Macmod Mending Jr., Emeline Aglipay Villar, Michael L. Romero, Luisa Loren Quaresma, Rodante Marcoleta, Robert Ace Barbers, Virginal Biron, Rodolfo Albano III, Romeo Acop, Gloria Macapagal Arroyo, Abigail Freyol Pascual, Harleen Neil Abayon III, Manuel Monsur del Rosario III. Honorable ex-officio members of the Committee on Justice, the Honorable Speaker Pantaleon Alvarez, the Honorable Deputy Speakers Reneo Abu, Eric Singson, Fredinil Castro, Romero Kimbo, Mercedes Alvarez, Gwendolyn Garcia, Maylene Garcia Albano, Pia Cayetano, Sharon Garin, Linabel Ruth Villarica, Bai Sandra Sema, Ferdinand Hernandez, Frederick Abueg, Rolando Andaya Jr., the Honorable Majority Leader Rodolfo Fariñas, the Honorable Senior Deputy Majority Leader Juan Pablo Bondoc, the Honorable Deputy Majority Leaders Arthur Defensor Jr., Roger Mercado, Ann Hofer, Vincent Crisologo, Aurelio Don Gonzalez, Victoria Isabel Noel, the Honorable Representative Ben-Hur Lopez, deputized by the Deputy Majority Leader Gerald Anthony Gullias Jr., and the Honorable Arnel T., the Honorable Minority Leader Danilo Suarez, the Honorable Senior Deputy Minority Leader Jose Atienza Jr., the Honorable Assistant Minority Leader Harleen Neil Abalion, the Honorable Deputy Minority Leaders Alfredo Garbin Jr., Eugene Michael De Vera, Anthony Bravo, Harry Roque, Luis Jose Angel Campos, and the Honorable Chairperson of the Committee on Accounts, Elenita Milagros Ermita Buhain. Your Honor, the roll call shows that there are 16 regular and ex-officio members of the Committee on Justice who responded to the call.
Mr. Chairman, I'm here.
With the 16 members, with 17 members present in today's hearing, 18 including Congressman Keith Belmonte, the chair hereby declares the presence of a quorum.
Mr. Chair, the minutes of the September 20, 2017 meeting was furnished to all members of this committee present today. In that connection, I move to dispense the reading, including the approval of the minutes of the September 20, 2017 meeting.
There being a motion duly seconded, the reading of the minutes of the previous hearing is hereby dispensed with, and the same is hereby approved. morning, esteemed colleagues, regular and ex officio members of this committee. Today, we have two items in our agenda, both referring to impeachment proceedings, which the committee had already taken up previously. For our first agenda, we will be voting upon the approval of the committee report and the accompanying resolution dismissing the impeachment complaint against COMELEC Chairman Andres Bautista. You will recall that on September 20, in a meeting of the Committee on Justice, where quorum was present, the committee found the impeachment complaint filed by attorneys Jing Paras and Ferdy Topacio as insufficient in form due to defective verification. The complaints attempted to cure the defect in their verification by filing a motion to admit substitute verification, which was denied by the committee on a vote of only 2 members in favor versus 27 against. Having denied the motion, the committee then voted on the motion to find the complaint sufficient in form. Again, with only 2 members voting in favor and 26 against, the committee declared the complaint insufficient in form. And guided by the previous ruling of the committee in the impeachment proceedings against President Rodrigo Roa Duterte and the second complaint versus Chief Justice Sereno, the committee dismissed the impeachment complaint against Chairman Bautista. Accordingly, on the third session day after the committee dismissed the impeachment complaint against COMELEC Chair Bautista, the committee returned the Paras Topacio complaint with a written explanation of the insufficiency. Pursuant to the rules, the committee has also drafted the committee report and the resolution dismissing the impeachment complaint, which is now before us for approval. Once approved, the report will be transmitted to the plenary where the report may be approved or by a vote of 1/3 of all members, which is 98 congressmen, the report may be overturned. In case the report is overturned by 1/3 vote of all members, the committee shall be constrained to draft the articles of impeachment, which will be transmitted to the Senate for trial. The next item in our agenda is the determination of the sufficiency of the grounds for impeachment against Chief Justice Maria Lourdes Sereno. On September 13, 2017, the committee conducted a hearing to determine sufficiency in form and substance of the 2 impeachment complaints filed against the Chief Justice. The impeachment complaint filed by Mr. Dante Jimenez and Attorney Eligio Malyari was found to be insufficient in form due to its defective verification and was accordingly dismissed. The complaint was then returned to the Secretary General on September 20, 2017 with the explanation as to the insufficiency in form. On the other hand, the impeachment complaint filed by Attorney Lorenzo Gadon was found to be both sufficient in form and substance. Pursuant to the rules, the Chief Justice was notified to file her answer within 10 days or 10 days from receipt of the notice by the committee. And on September 25, 2017, the committee received the answer of the Chief Justice to the Gadon complaint. 3 days later, the committee received Attorney Gadon's reply to the Chief Justice answer, and finally, on October 2, the committee received the rejoinder of the Chief Justice to the reply. The Chair notes that all the pleadings mentioned were timely filed before the committee as provided for in our rules. With all the pleadings now duly filed before the committee, copies of which have already been distributed to the members, we now proceed to the next stage of the proceedings, which is the determination of the sufficiency of the grounds for impeachment. In determining sufficiency of grounds, we shall now take into consideration not just the complaint, but also the answer, the reply, and rejoinder filed by the parties. The issue that the committee will need to resolve now is whether or not, based on the pleadings filed, are there sufficient grounds for the impeachment of Chief Justice Sereno, and or if there are also grounds to conduct further hearings thereon. I would like to remind the members of the committee that Article 11 of the Constitution only lists 6 grounds for impeachment: culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, and betrayal of public trust. And in this impeachment proceeding, Attorney Gadon raised 4 of the 6 grounds for impeachment, alleging 27 acts constituting the offense charge, which we will now consider in today's hearing. Thus, we will now determine whether, based on the allegations in the complaint and in all other pleadings, there are sufficient grounds for impeachment. And should the committee find that there are sufficient grounds, we will then conduct a hearing to determine whether there is probable cause for the impeachment of the Chief Justice. For the information of the members and of the body, the lawyers of the Chief Justice filed 2 letters addressed to the committee. Attention to this representation. The first was received by the committee on September 28, 2017 with the subject, the right to confront and cross-examine witnesses in the matter of impeachment of Chief Justice Sereno. And likewise, yesterday, another letter with the same subject and addressed again to the committee was received by the committee, and we have distributed copies of this letter, and we will later make a ruling on this letter request after discussing the contents thereof. I suppose you have also read these letters. Just some points to ponder on. The right to counsel and or right to cross-examine is not being withheld by this committee. In fact, this is recognized, but then there are certain rules that we have to follow. What is being asked of us is the right of the lawyers to cross-examine. So just to make that clarification, we are not withholding any right of the respondent because we are allowing it, except that on the request that the lawyers themselves conduct the cross-examination. This is one thing that is not allowed in our rules, and therefore I will throw this to the body for decision so that everyone will be guided accordingly. Likewise, in one interview, I was asked about the Chief Justice herself conducting the cross-examination, and I think this is my own personal view on the matter, considering that the Chief Justice is a lawyer, and the complainant, Attorney Gadon, is likewise a lawyer. Perhaps this may be a good and interesting proceeding that may happen before this committee, because if we allow cross-examination by either party, then this will enrich our proceeding. On the other hand, if we allow the lawyers, how can we cross-examine the lawyers? Or how can we ask clarificatory questions from the lawyers who is not the party himself or herself? So this is one thing to ponder on also as a committee. And so I I'd like the members to be minded of this important aspect in this proceeding. On another point, we are only at the stage of determining sufficiency of ground to impeach. And so this is not yet the hearing itself that we will call, because that will happen after the sufficiency of grounds had been established. So for today's hearing, it is only really among us members of the Committee on Justice who will be allowed to vote, and just for purposes of discussion, the parties not being still necessary because we are not yet conducting the hearing proper, where evidence will have to be adduced and or considered, and our compulsory processes already employed by this committee. Third is that this impeachment is akin, although not a criminal case, this is akin to preliminary investigation in criminal cases. And the only difference is that the penalty here is simply removal and not imprisonment, or so this is not criminal in nature. So, but nonetheless, we should be guided also by the rules on criminal procedure, as which is supplementary to our internal rules. And in preliminary investigations, in fact, the right to examine and cross-examine is not even allowed in preliminary investigation in criminal cases. What is allowed is clarificatory question by the prosecutor, and we are acting here as prosecutors actually, or investigating prosecutors, and therefore we are the ones to ask for clarificatory questions if there are things that are not too clear on the allegations and the answer and any other pleadings filed before us. So having said that, as a guidepost, then now I would now like to proceed to the first item in our agenda, and the committee shall now entertain any motion with respect to committee report and the accompanying resolution dismissing the impeachment complaint against COMELEC Chairman Bautista.
Mr. Chair, in relation to item number 4 of our agenda today, which is the approval of the committee report in relation to the impeachment complaint against Commission on Election Chairman Juan Andres D. Bautista, filed by Attorney Jacinto V. Paras and Attorney Ferdinand S. Topacio, endorsed by Representatives Gwendolyn F. Garcia, Abraham N. Tolentino, and Harry Roque. The committee report, unnumbered, was furnished and circulated to all the members of this committee prior to the start of this hearing. And in that committee report, it has the following dispositive portion. Now, be it resolved by the House of Representatives to dismiss the impeachment complaint filed by Jacinto V. Paras and Ferdinand S. Topacio against Commission on Election Chairman Andres D. Bautista for the reason that the said complaint is insufficient in form due to its defective verification. In that connection, Mr. Chair, I therefore move for the approval of this committee report.
Second, Mr. Chairman.
There being a motion duly seconded and hearing no objection thereto.
Mr. Chair.
What is the objection? Deputy Speaker.
Consistent with our position, Mr. Chair, we still maintain that insufficiency in form strictly by the present unamended House rules is not a ground for dismissal. And if we were to follow our own House rules, this complaint found to be insufficient in form shall be returned to the Secretary General. I am reading from Section 4, Rule 3. And upon return to the Secretary General, the Secretary General shall then, with the committee's written explanation, within 3 days from receipt of the committee resolution, return such to the complainant. We are just being consistent to our position, Mr. Chair.
Thank you, Deputy Speaker Garcia. There is a motion duly seconded and there is an objection. The matter has been extensively discussed in the previous hearing, and I guess there is no need for further elaboration on this, but nonetheless, we will divide the House to vote upon the matter because of this objection. So those who are in favor...
Mr. Chairman, are we voting on the report only or including the resolution? So may I introduce amendment before we vote on it?
Thank you, Majority Leader.
Yes, sir. In page 11 of the committee report, the second to the last paragraph, may I propose an amendment to make it very accurate. It should state that after due discussions for and against the motion of Representative Garcia, and there being objections to the motion, the chairman put the matter to a vote with only 2 votes in favor and 26 against. The motion, the amendment is, we intercalate this phrase, the motion to declare the complaint sufficient in form was defeated, and the committee declared the complaint insufficient in form. May we please include this because it is misleading the way it is worded. And also in the resolution, Mr. Chairman, in page 3 of the resolution on the second to the last paragraph, may I propose that it should state, whereas in its meeting held on September 20, an emotion to submit to an emotion to substitute, to admit the substitute verification with a vote of 2 in favor and 27 against the motion, the committee resolved to deny the motion. And lastly, in the second the succeeding paragraph, it should also state, whereas, same page, second page, the last paragraph. Walang page dahil tatatlo eh. Anyway, this is the second page. The last paragraph, it should state, whereas during the same meeting, an motion to declare the Paras Topacio complaint sufficient in form, 2 voted in favor, while 26 voted against the motion. Consequently, the committee declared said complaint to be insufficient in form for the reason that the verification was defective. Kasi po the way it's worded now is, whereas during the same meeting, an motion to declare the Paras Topacio complaint sufficient in form, the committee declared said complaint to be insufficient in form by a vote of 2 in favor and 26 against. So misleading po. I propose only those amendments, Mr. Chair.
Mr. Chair.
The proposed amendment, okay, Kong Henry.
Yes, Mr. Chair. This representation being the movant of the main motion respectfully admits all the amendments introduced by accepts all the amendments introduced by the Honorable Distinguished Majority Leader Rodolfo Pariñas.
Mr. Chair, I would thank the Majority Leader for calling our attention to the House resolution, and in the same House resolution, may I also propose that my name be taken out as one of the proponents of such resolution dismissing the impeachment complaint.
On what page is that?
This is the first page with the listed sponsors of the resolution, I would wish to call the attention of the committee that my name is included.
The names of the authors. Naman ito.
Yes, the movement respectfully accepts the amendment introduced by the Honorable Deputy Speaker,
Thank you.
Garcia.
Amendment by deletion.
So we are now ready to divide the House to consider the motion as amended. So all those in favor of approving this committee report together with the resolution, please stand up. Thank you, ladies and gentlemen. Those who are against, 19. Those who are against the motion, please rise. With 19 votes in favor of the motion, against 2 who are against the motion, the motion is carried. The committee report and the accompanying resolution is hereby approved. We now go to the next item in the agenda, which is determination of the sufficiency of the grounds in the verified complaint for impeachment against Supreme Court Chief Justice Maria Lourdes Sereno, filed by Attorney Lorenzo Gadon and endorsed by 25 House members.
Mr. Chairman,
Yes, Kong Edson.
Mr. Chairman, considering that there are 37 acts included in the complaint for the impeachment of the Chief Justice, as mentioned by the Chairman himself, may we suggest, Mr. Chairman, that these 27 acts should be voted upon separately rather than in mass.
Any other comment on the manifestation of Congressman Lagman?
Mr. Chairman, I think the proposal of the distinguished Congressman Edsel Lagman is reasonable. But I think it is out of context insofar as proper procedure is concerned. Because if we are going to vote on it one by one, we are going to violate the very essence of what we are doing. That is determination of the sufficiency of substance. Because in ground, because in such determination, there is a hypothetical admission of each and every allegation in the complaint. Therefore, if we vote one by one, in effect, it will be inconsistent with the rule that when we determine the ground on whether it is sufficient or whether they are sufficient, we go in conflict if we vote one by one. That's the observation of this representation, Mr. Chairman.
Mr. Chairman,
Thank you, Deputy Speaker. If I may just also mention that on this matter,